Are you well, Justice Molemela?
You just switched it off.
Press the mic, please, Justice.
Sorry about that.
No, but I'm unmuted.
You, Chief Justice.
Is there a problem that end?
Yes, I'm the one that pressed the mute button.
Oh, I see.
Yes.
Okay, all right. Are you well, Justice?
Yes, I'm well, Chief Justice, under the circumstances. And how are you?
I'm very well, thank you. I don't see your face. I want to tell whether you are still a bit nervous, I must help you along, or whether you are comfortable, you're ready for all questions. I don't know why they are hiding. Yes, there you are. Okay, now I know what to do. I know what to do. Now, you've traveled quite some journey as an attorney. Just give us a bit of details about that attorney's firm by women that you were running.
Thanks, Chief Justice. I think the firm was established in 1996, if I'm not mistaken. And it was your typical firm that handles everything. We used to call firms like that general dealers, because you had to handle all aspects of the law. And so we covered all areas of the law, including conveyancing. And maybe what I need to do now is just to pause and mention that before establishing that firm, I opened my own practice as a sole practitioner. And it was quite a bold step, because I intended doing conveyancing as well, even though I was not a conveyancer. At that stage, I had only started attending conveyancing courses. I wrote the conveyancing exam and passed it. And at that stage, I had already established that firm. So months later, in fact, our paths crossed, meaning the path of Justice Kubushi and my path crossed at the conveyancing course, and we immediately clicked, and soon thereafter we established a practice, and as they say, the rest is history. So it was a fairly successful practice. I know that we were featured in one of the magazines. That magazine is no longer in existence now, forgotten the name of it. And I think a year or two later, Justice Kubushi was appointed as a state attorney, so she left the practice, and I carried on my own. And the practice was a success. We were on several panels of several banks, ESCOM, SASOL, and so forth. So it was a fairly successful practice, but it became too successful and too difficult to manage for one person. And so at some point I decided, okay, I wanted to specialize in labor law, and I thought the quickest way of handling that would be to maybe focus on labor-related matters, and that's how I ended up at the CCMA. But the years spent at that firm were very, very special. People often said they did not know how to refer to the firm because it was a female firm. Because usually when you addressed a letter to a firm of attorneys, and invariably the partners would be male, it would be addressed as messieurs, so and so. And so people were saying, but we don't know what to say in relation to you. Is it messieurs? What should we say? And they resorted to mesdames. Yeah, so that was the era it came and it went. And I went on to do other things, Chief Justice.
Well, just to clear the coast, you made reference to getting some work from ESCOM. I take it that there is nothing to give us reason to believe that you might have to present yourself before the Zondo Commission.
Not at all, DCJ, not at all.
All right. The High Court. How did it prepare you for the SCA? How would you say your judge presidency also equipped you for the SCA? How would you say a combination of those two experiences and your experience at the SCA prepared you for the Constitutional Court? How would you say your acting instinct at the Constitutional Court, together with all this, gave you confidence that you're ready for the position you're now applying for? Just as I've said to all other candidates, and we will be saying to others, it's time now to brag. Even if you are humble, you would be doing yourself a lot of harm if you were to try and play the humility card. Just brag.
Okay, thanks, Chief Justice. Maybe let me just reverse a little and return to the point where I said that at our firm we were a general dealer. Even the firm that I served at before, Pete Jake Moloi, was a general dealer. And that was very, very helpful because it exposed one to different aspects of the law. And so early in 2005, a position became vacant at the Free State High Court. And an organization approached me and asked me to make myself available. And at that stage, I declined. I said, I will not make myself available when I have not acted. I know that to act is actually you have to be invited. So there's no guarantee that I'll be invited, but I do not want to make myself available for that position when I have not been exposed to what it is like to actually be in that position. Because with acting, you find there are people that come and act, and after acting, they decide, no, thank you, this is not for me. There's too much pressure, or it's too isolating, or whatever the case may be. People advance different reasons for not accepting appointment. So at that point, I declined and said, I think I want to act first and make a decision at that point whether I'm going to be appointed or not. And later the same year, in September, so I did not make myself available for that vacancy, and it was filled. And later in the same year, the Judge President of that time, Justice Judge President Malherbe contacted me and informed me that somebody had recommended me and invited me to go and act. I went there and acted for a month. And on the last day of my acting stint, the Judge President and a senior judge from that court invited, there were two of us that were acting at that stage, so they invited us for lunch. And during that luncheon, the senior colleague asked me whether I was going to make myself available should a position become vacant. So I said to him, I don't think so. I think the workload is too much. I think I first need to adapt. And so he said, well, I don't think it's a bad thing, because I too was invited to act here. I acted, and immediately after my acting stint, they actually wanted to appoint me, but that was before the JSC days. So they wanted to appoint me. That was him now saying this to me, but I declined because I too felt that I was not ready, despite the fact that I had been practicing as an advocate for quite some time. And so I left, and soon thereafter, the judge president invited me again to go and act. And I went there, I acted for a term, and at the end of the acting stint, the same colleague asked me, well, I'm asking the same question again. Are you going to make yourself available if a position becomes available? I said, I'm not sure. I still think that there's a lot of work here at the High Court. I still think that I need to adjust and things like that. And he said to me, look, I can tell you now that I think you are ready. It gets better with time. I've been a judge now. He had been, at that stage, he had been a judge for more than 15 years or 20 years thereabout. And he said, I've been a judge for this long, and I can assure you that it gets better with time. So I am encouraging you to make yourself available should a position arise, because I think that you are now ready. And a position became available. I again did not apply, but in the meantime, I was working hard. Now working at the pace of a judge, trying to work at the pace of a judge to equip myself just in case I became interested in the position. I've always been a hard worker, Chief Justice, and having been a female in practice in a very male-dominated environment, there were a lot of doubts. Sometimes clients would come at my erstwhile firm, they would come, and in the main, the firm handled criminal matters, and I would overhear some of the clients saying, I don't want to be represented by a female. So that actually encouraged me to work harder. So the more I felt that people doubted me, the harder I worked, and I think it paid off. So in 2007, there was an advertisement that I saw where they were inviting ladies to go and participate in a course. I think it was pioneered by the former Minister of Justice, Bridget Mabandla, where they were trying to empower women with the necessary skills to make them judges. Just before I applied for the position, I was again invited to the Free State High Court to go and act there, and I accepted the invitation. But I felt that I would gain a lot from attending that course because it was a course that was dedicated to equipping females with the recognition that most females had not been exposed to certain aspects of the law, like, commercial law and so forth, primarily because of the stereotypes that people had about women. And so I attended that course, and it helped me immensely. I could not attend the last part of the course. I think it was the last 2 weeks of the course, if I'm not mistaken, because then I went and I accepted an acting appointment in the High Court. And when I was there now on the third acting stint, I actually realized that it was much, much easier. And I thought to myself, the 2 previous acting stints have assisted me, and now this course also has prepared me for the bench. And I think I am now at a stage where I can say, if approached, I will make myself available. So I I attended the course, acted in the Free State, and was invited to act in Gauteng. And thereafter, there was a position that was advertised in the Free State, and I decided to apply, and I was appointed. I'm just trying to say, Chief Justice, I was biding my time, and in the meantime, I was preparing. I was equipping myself. I was reading. I was studying, spending long hours reading and preparing myself. And studying and reading has become second nature to me, which is why I have never really struggled at any of the courts, be it the High Court, be it the Labor Court, Labor Appeal Court, Competition Appeal Court, and so forth. I have a high work ethic, which I developed over the years, and I find that it helps a great deal. Nothing beats preparation. And so I have spoken and mentioned how attending that course immensely helped me in shaping me to what I am today. I'd like to point out that I have attended several other courses under the auspices of SAJE, the Judicial Education Institute. And I found that these courses too were they were very, very helpful. They are courses that are intended to equip judges who have not been yet exposed to certain areas of the law, for example, maritime law, intellectual property rights and so forth, intellectual property law and so on. But they are also refresher courses to those judges that are already experienced, but who need to refresh. And somebody might ask, why would an experienced judge need to refresh? I will make an example, and this is the example that I'm making, that there was an era in this country when we were under the apartheid rule, when none of us knew anything. We knew that there was a concept or notion of a Bill of Rights, but it was non-existent in this country. Fundamental rights were being trampled left, right, and center with the blessing of the law, and also with the blessing of the courts, unfortunately. I know there's a judgment. It's a 1934 judgment of the court at which I'm serving. At that time, it was referred to as the Appellate Division. I think it's Sachs versus the state, if I'm not mistaken, where the judge actually in his judgment openly stated that if the legislature has laid down a statute that encroaches on the liberties and freedoms, then that law had to be respected. It's quite shocking, but we do understand that that was in 1934. And so it went, and we know the history of the country. And we know that the same court in the 80s made a pronouncement in terms of which the former justice of the Constitutional Court, Justice Albie Sachs, and other political prisoners were denied the right to have access to newspapers and so forth, purely on the basis that they were regarded as political prisoners. And the judge had the audacity to actually say that, but the whole purpose of detention, that kind of detention, is to extract information. So indeed, inmates of that nature should not have access to information in the form of newspapers, magazines, pens and paper to write and things like that. That too is a shocking judgment if you consider where we are now in terms of our human rights. An outright violation of human rights, receiving a blessing in the form of a judgment of the Appellate Division. So where I'm going with this is that it is quite clear then that there was no culture of human rights at that stage. And then we had the Constitution, so which is something new. Clearly, there had to be a huge paradigm shift or a change in mindset in terms of the thinking, moving from an era where there was parliamentary sovereignty to an era of constitutional supremacy, and we are now in a constitutional democracy. So courses were offered on constitutional litigation to legal practitioners, and I know I'm one of those that attended those courses back then. I think that was in 1995 or 1996. But obviously, the existing judges or judges that were, were already serving as judges, they also had to, let me refer to it as decolonizing the mind. They also had to decolonize their mind to have that paradigm shift to now start thinking along the lines of the values of the Constitution, the fundamental human rights that are entrenched in the Constitution. And so they too had to attend courses. So that was something new to them as well. They were already experienced. They had been on the bench for a long time, but they too had to attend courses. And I speak with, with no fear of contradiction when I say that I know that we have all embraced, the judges have embraced the values that are enshrined in the Constitution. And so all the courses that have been offered by Sajay, intellectual property, maritime, tax law, and so forth, have been very, very helpful, not only to me, but to other judges as well. And how do I know this? I know this because I've been serving as a judge of appeal since 2012, meaning I could sit and review the judgments of my colleagues. And I have seen that more and more and more colleagues, let me just say there's a huge improvement in the quality of the judgments. And it has often pained me to hear people talking about someone not having been exposed to commercial law just because at the time when you were an attorney, maybe your area was or focus was criminal law or something else. The courses have been very, very helpful to all the colleagues, including myself. And so I'm at a stage where I consider myself well-versed with all areas of the law that I can comfortably say to you here today that I know that I will be equal to the task at the Constitutional Court. I am lucky enough to also have acted at that court. And so I know what is waiting for me there. I have demonstrated, after acting in that court, I acted there in 2015 and went back to my division. And maybe here I will interrupt myself, Chief Justice, just to say, you will recall that during my interview for the position of President, I mentioned the advantages that can be derived from acting. And I said that an acting appointment is not beneficial only to the candidate who's acting, in the sense that it empowers that particular candidate, it gives that particular candidate personal growth. But it is also beneficial for the entire legal profession in the following sense, that if you are acting as a judge in the High Court and you are a magistrate, when you go back to the magistrate's court after your acting stint, I can guarantee you will not be the same person. There's a famous quote by Justice, I think it was Justice Wendell Holmes, who said that a mind, once it has been stretched to a new idea, it will never go back to its original dimension. And I can attest to that. I've seen it. And, you know, even in respect of people that are coming from the bar, they come there, they act, they go back, and they come and give feedback and say, this has been an enriching experience. And it's not only enriching to the individual, but to the entire bar, because then members, say in the magistracy, all the magistrates feel confident to go to this colleague who has acted in the High Court to say, I have this problem, legal problem, how can I deal with it? At the bar, the colleagues go and consult that colleague who has acted to say, how can I deal with this? And then I mentioned as well that acting in another court is also beneficial to the court, to the particular court. And I think having acted at the Constitutional Court benefited my court, because I went back, I imparted the knowledge that I had acquired from the Constitutional Court, and you know, continued to operate as if I was still at the Constitutional Court. That is why, Chief Justice, when you peruse the judgment of Tswaedi versus S, you will see that it is quite a detailed judgment. You said I can brag. I think I can mention that when I read that judgment, it gives me great pride. And I think I have demonstrated in that judgment that even though I was at the High Court, I was still operating at the level of the Constitutional Court. I have comfort in saying this because a number of passages from my judgment have been cited with approval in the Constitutional Court judgment of S versus Mlungwana. So not only is it a confirmation that I came to the right conclusion, but it also says that the reasoning was also solid. And in the judgment, you would have noted that I referred to various authorities, including foreign judgments. So, Chief Justice, my whole history, the journey that I have traveled even before becoming a judge, just from that day when I was nominated, then somebody approached me in 2005, before I even acted, to say, we think you should make yourself available. There was a huge paradigm shift, and I started operating at a high level. And I read a lot. I'm talking now about just literature that has nothing to do with the law. At the beginning of every year, I read 1 or 2 books just to sharpen the saw or to make my skills even better. And there's a book that I read, The 4 Agreements by Miguel Reitz. And Miguel Reitz in that book says, if you want to have a happy life, there are 4 things that you need to do. And he says, the first agreement is to be impeccable with your word. And the second agreement is not to take things personally. The third agreement is not to make assumptions. And the 4th agreement is always do your best. I think those 4 agreements have helped me a great deal in becoming what I am today. And I have applied it, it has become my Bible. And it gave me great pleasure when I read the comments from different professional bodies where they described me as someone with integrity, somebody who works hard. And I said, okay, there you have it. I already tick 2 boxes in that book. I think, CJ, this is where I would like to leave it.
All right. Now, just apart from Tswaedi, can you just share with us a case or a few cases either from the High Court, the SCA, or Constitutional Court, that demonstrate your ability to contribute meaningfully in the development of the jurisprudence at the highest court in the land. Just some examples, if they come to mind. I know an interview is a very strange thing. You get interviewed, something doesn't happen. As soon as you walk out of the door, you remember something quite potent that you should have shared. Just in case there are additional cases that you want to hold out as demonstrative of your capability to function and function effectively and in the apex court and help shape our jurisprudence in the right direction.
Yes, I'll mention the case of Murudi versus Northern Cape Housing. It's a case where I wrote a dissenting judgment. It was a panel of 5, and I was flying solo. So I wrote a dissenting judgment, and okay, let me just step back a little bit and say, when it comes to rescission of judgment, a judgment can be rescinded on various grounds. And one of the grounds is that if it can be rescinded if it is a judgment that was erroneously granted. And the whole debate was whether that particular judgment had been erroneously granted. And I found in my judgment that to the extent that the litigant in that matter, the litigants in that matter were present in court, but were not given a hearing, the judgment was erroneously granted because they were present, but they were denied a hearing. Audio alteram partem was not observed. That judgment was overturned by the majority judgment was overturned by the Constitutional Court, and the Constitutional Court in its judgment stated that I was correct in my interpretation. And so that judgment has made a contribution in relation to that particular aspect relating to rescission of judgment. It has just clarified that a judgment is erroneously granted even if a party is present in court. So I would say that's the development of jurisprudence that has happened. I would also mention the judgment that I wrote. I think it's provincial government versus Oudtshoorn municipality, Chief Justice. At first blush, when you read it, you might think this is just an ordinary run-of-the-mill, straightforward judgment confirming an order of constitutional invalidity. But when you read the judgment, you will then see that I deal with the aspect of separation of powers. I refer in that judgment to cool ideas and to, I think it's the National Coalition judgment. And even where both parties were organs of state, even where both parties were agreed that the particular provision was unconstitutional and were agreed that there should be reading in other words, that we found that the particular section of that legislation, the Municipal Structures Act, was deficient. And there was a suggestion that, okay, to make it comply with the Constitution, you could add this part. And both parties were agreed that we should do reading in and add the particular part that says, to the extent that it is not inconsistent with the Constitution. The court still went to town dealing with the aspect of separation of powers. We did not just rubber stamp the decision to say both parties are agreed that we can do reading in, and so we are going to do that. There were a number of considerations, and in the end, we agreed. We declared that particular provision unconstitutional, and we also made an order stating that they should be reading in to make it compliant with the Constitution. There are a number of judgments. I can't, recall them from the top of my head, Chief Justice. There's also the judgment of Harvey, which concerned the rights of the adopted children. It related to a testament will that was drawn in 1953, in which the testator had said that he was leaving his property to all his children in equal shares. And the debate was whether his children also included the adopted children. And I took the view that it included the adopted children, even though the adopted children were not in existence at that time. And there was a similar matter from our court, but now relating to whether a will can survive constitutional scrutiny if it has a clause that says that the beneficiaries shall only be females. So my judgment was quoted in the appellant's heads of argument in that particular hearing. And I noted that in the judgment itself, there's a part that refers to what I stated in Harvey. So although it was not, Harvey, the judgment of the Constitutional Court in De Jager was not in relation to my judgment, but it was on a similar matter. And in the De Jager judgment, the Constitutional Court held that my reasoning was correct. Not in so many words, but there was a reference to a particular passage in my judgment which was quoted with approval. So I think that's the contribution that I have made. As I said, Chief Justice, there are a number of them, but those that are the ones that I can immediately recall. I have said in...
Thank you very much.
Okay.
Yes, carry on.
All right.
Please continue.
I have participated in a number of appeals. I mentioned that from 2012, I became a judge of the Labour Appeal Court and the Competition Appeal Court. I was on the panel of several judgments, and there are several judgments that ended up at the Constitutional Court, confirming the judgments, even though it was not my own personal judgment, but confirming the judgments in which I was a panelist. So now being a panelist, it means that you are part of the decision, you were part of the debate, you made a contribution in relation to the conclusion. And so at the Supreme Court of Appeal, I've participated in many appeals, more than 100 already. I have written a few dissenting judgments that received approval from the Constitutional Court. I have managed to, both at the Labour Appeal Court and at the Supreme Court of Appeal, sway a decision where the prima facie view was to find in favor of a particular party, but because of my contribution, we ended up, coming to a different conclusion. So that's the contribution that I have made. My contribution, in other words, is not confined to only to the judgments that I have penned, but to the judgments where I was a panel member. I made a contribution to the final product that came out.
Yes. Thank you, Justice. Colleagues, would you please indicate if you want to put questions to Justice Molemela?
Nyambi.
Lucas.
Sigogo.
Matonsela.
Lamola,
Schlemer,
No JSC.
Tepe,
Singh,
Thank you.
Deputy President Petse,
JP Mlambo.
Honorable Nyambi.
thank you. Morning, Judge Molemela.
Good afternoon, Commissioner.
As somebody that was leading a division in the Free State, and you happen to get the opportunity and be appointed to the SCA, we have learned for a number of years about the issue of the top 6. You left Free State as a leader. Then you went to the SCA, and you are a woman judge, and you have been leading in the Free State division. Will you share with us some of the stereotypes we have had to deal with as a woman judge, and how we have managed to remain focused and still be competent, given the challenge of being a woman judge and getting to an environment where you have the top 6?
Thanks, Commissioner. Chief Justice, I think in my previous interview, this very aspect was alluded to, and I mentioned the problems that we had encountered. I think I did mention in that interview, if I didn't mention it, I am mentioning it now, that for me, the atmosphere in that court was a culture shock, because I came from a very, what you can describe as a very collegial court, where the colleagues made a genuine effort to foster collegiality. And I'll make an example. When I started acting at the Free State Division of the High Court, when the Judge President was orientating me, he said to me, look, try by all means to make attendance at the tea room as much as possible. We do understand that you will not always manage to do this, because sometimes you are in a hearing and you are of the view that it would be a disruption to adjourn the proceedings just to make an attendance in the tea room. However, on the first day of the term and on the last day of the term, tea room is compulsory. And so that has always been the practice in that division. First day and last day of the term, we gather in the tea room. We literally shake hands with one another, make small talk, regarding how the recess was, what were you doing in the recess and things like that. And if it's the last day of the term, just a chit chat, where are you going, when are you leaving, and things like that. And I think things like those, Chief Justice, are very, very important in fostering collegiality. And we also, had this practice of having at least once a term, we have lunch with all the colleagues. You bring your own lunch box and we all sit together and, around the table, and we chit chat. And I remember at one stage I was at the Competition Appeal Court, and our cases are normally heard at the seat of the Western Cape Division of the High Court. And it was the last day of the term. And so I was telling a colleague that I was happy to be going back to Bloemfontein because I had some traveling to do, because we have an outing as judges for the weekend. And this colleague was actually shocked to say, you have an outing as judges? And I said, yes. And we actually went away for a weekend. All the judges of most of the judges of that division. we went to a small town, some maybe 100 kilometers from Bloemfontein, and we all had fun there. And it's nice, you know, to interact and to talk about other things other than our work. And I would say collegiality is very, very important. And I think I did mention at the last interview that, you know, when you are being collegial to your colleague, it's not as if you are doing this colleague a favor. It's actually set out in so many words in our code of conduct that we must avoid personality issues and foster collegiality. And so I came from a court where I will not take the credit for myself and say I'm the one that introduced it. When I got there was collegiality already. You know, one of the unwritten rules in the tea room was that we all chat together as a group. So we would sit like in the form of a circle, and the conversation would be for everybody. So you'd have to speak loudly so that everybody can hear you and we all participate in the same conversation. So you would not just be talking to the person right next to you. And I think it went a long way to fostering collegiality. That was the environment that I came from and went to that judge, and things were not the same. I think in the past interviews, it has already been mentioned what the problems were in that court. But we had a diversity training subsequent to that interview. And I think that diversity training helped a great deal. We had a frank talk, all of us had a discussion with a facilitator present. And I remember, and everybody was brutally frank. And I remember at some stage, the facilitator said she was giving us an hour or so to have a one-on-one with any colleague that you seemed not to be getting along with. And I used that opportunity to go to the other colleague that I had, you know, referred to in my previous interview. I went to him and said to him, listen, I think there's a problem. Let's get to the bottom of it. And we had a nice chat. And thereafter, you know, he just looked at me and he didn't say anything. And I was about to leave and saying to myself, well, this is not even working. And as I was about to leave, he actually reached out to me and hugged me, and we hugged. And ever since then, you know, the relationship has been very, very cordial. He refers to me as my hoops, you know, from that tension to where we are now. Strides have been made. So even though we had problems in the past, Chief Justice, we had the diversity training. We had a meeting pursuant to that diversity training where we discussed things, and we actually agreed amongst ourselves as judges that everybody has permission. If a colleague has offended you, then you have all the right to privately go and confront that colleague. So I think that has worked. You know, there's an understanding that we have to get along because we work together as a team. And speaking for myself, since then, I have not had any difficulty with any other colleague. And in my nature of, you know, trying to be welcoming to colleagues that are acting, I have reached out to the colleagues. I know that there's a committee that specifically interacts with people that are acting there for the first time to orientate them. But I reached out especially to my sisters, the female acting colleagues, and said to them, know that when you are on the panel, your view is as good as the view of any other panelist. There's no more seniority now. You are entitled to ask a question anytime you want to ask a question. You are entitled to be treated with respect. And if for whatever reason you are of the view that a colleague has not treated you with respect, you have all the right to discuss it with that particular colleague. So I think the diversity training has been successful, Chief Justice, and the frank discussions that we have had in our meetings. So I'm not complaining about lack of collegiality at the SCA. I think we have gone. I think we have gone past that now. And after that diversity training, the lady was very, very helpful because she was talking about many aspects, and including unconscious bias. And in that very venue, one of the colleagues actually mentioned openly to say, yes, I think I acknowledge I have been privileged because of my race. So people were just open with one another. And it gave me an opportunity to reflect. And I remember we once had a difficult moment and we had a meeting. And on my way to court on that particular day, a song was playing on the radio, and it happened to be a song by Coldplay. And in the lyrics, something just stood out to me. And this is something that I mentioned at our meeting, to say, as colleagues, we must introspect. We must have a serious conversation with ourselves and introspect and ask yourself this question. And those are the lyrics from that song. Am I part of the cure or am I part of the disease? And, if you apply that, there's bound to be improvement. And I think the measures that have been taken up until now have assisted a great deal. I must also give credit to my sister, the leader of that court, Justice President Maya, because she created the safe space within which to exhale and to acknowledge that there are problems and for us to resolve those problems.
Thank you. My last question. I see that you are pursuing an LLD despite your busy schedule. How important is it for you to further your studies, and how do you see this impacting on your work, especially the office of which you aspire, the CC?
Yes, thanks, Commissioner. I had to put that on hold because I was due to take the remaining part of my special leave, which we normally refer to as long leave. And I had planned to do all the preparation for the thesis and everything during long leave. However, I was requested not to take long leave at that particular time due to some operational reasons at the court. And so I had to postpone it. And it's only now that I've taken leave. And so that is something that I'll be focusing on during my private time. It's very, very hectic. The workload it's hectic at that court. You really don't find a lot of time to do other things than work. As it is, I work 7 days a week to cope with the workload and so forth. So I have to actually find extra time to devote to studies and things like that. But I find that most of my life, in fact, most of the qualifications that I have are qualifications that I got while studying part-time. So I think I have found a way of multitasking, and to ensure that it does not interfere with my responsibilities at the court. So one day I will do it, but at the moment I had to put it. I actually had to put it on hold, and will only be focusing on it now. I'll see how far I go.
Thank you, Judge Molemela. Thank you, CJ.
Thank you, Honorable Nyambi. Honorable Lucas.
Thank you very much, CJ. Good afternoon, Justice.
Good afternoon.
Molemela.
Good afternoon, Commissioner.
Part of my question have been covered by the question that was asked by Honorable Nyambi. But there is just two issues that I want to raise with you, and possibly you can respond to it. I see that at a very early stage already, you started to act as a judge, and you were one of the privileged few that got that kind of exposure. And I also noticed that you spoke of an absence of a culture of human rights that was non-existing according to what you exactly said. So one of the issues that I would want to know is what have changed exactly. Is there any positive aspects that you want to highlight? And secondly, as someone that has had that privilege that I've just mentioned, what have you done constructively and in a very structured fashion to make sure that you develop other women that find themselves in the same position that you found yourselves a few years ago? I think that is the remainder of the question that I wanted to ask to you. Thank you very much.
Yes, thank you, Commissioner. What has changed is we now have a constitution. We have a constitution that is the supreme law of the country, and it permeates through all the branches of the law. So the judgments that I referred to of the Supreme Court of Appeal are old judgments. The one is 1934, the other is, I think it was in the 80s, the one in relation to Justice Sachs. So that was before the advent of the Constitution. And all organs, all branches of the state are obliged to promote and uphold the Constitution. So it's not a question of whether one wants to recognize the Constitution or the fundamental rights that are entrenched in the Constitution or not. Nobody can wish it away. It's there, and everybody has to comply with it. And that is what has changed the jurisprudence in this country. And in relation to a structured approach of helping other women, this is something that I have been doing for quite some time, even before I became a judge president. But when I was a judge president, then what I decided to do was to allocate every acting judge, not only females, every acting judge, I would call them to my chambers and have a discussion with them, orientate them, and tell them that they should choose one colleague amongst the colleagues at that court, whom they can trust, for purposes of mentoring. They should approach that colleague, because mentoring is a two-way street. You have to trust the person who's mentoring you, to know that there's confidentiality, to know that when you open up to this person that I think in this particular area of the law, I'm not well versed. This person will not go around talking about you and will instead try and help you. So there has to be trust, mutual trust. Hence, I said, choose anybody that you trust. And if that person has not accepted to be your mentor, come and tell me so that we can make a plan and find you somebody else. Invariably, it has worked. And at the end of the term, I then interact with both parties to ask how it went, and it has worked very, very well. When acting for the very first time as a judge is a daunting task. And so you need somebody to hold your hand. You need somebody who will be sympathetic. In fact, not only when you are acting as a judge for the very first time, when you are acting in a new environment. So that would also include the Supreme Court of Appeal and the Constitutional Court. When you are acting for the first time, I mean, it's a completely new environment. It's a higher court. It's got its own ways of doing things that you are not familiar with, and so on and so on. So those are all the considerations. And mentoring and coaching goes a long way in empowering this particular person to be able to perform their tasks. Because if you are not happy at work, if you don't have inner peace at work, it actually affects your performance. So sometimes people are described as being not up to the task or not up to scratch, only to find that people are just overwhelmed by the new environment. And if you don't have a mentor, you'll be lost at sea. Everyone needs a mentor. So I do that. And I encourage mentoring, other colleagues to actually volunteer. So you don't just wait until somebody comes to you and says, can you help me? So in the High Court, actually, on that first day, when you are introduced, you are actually also informed that the other colleagues give you the assurance that if you need any kind of help, you can go to any one of them. It will be up to you really as to whether you are going to go and seek help, because you can't impose yourself on someone. Someone must come to you and seek help. I have sought help from colleagues at the High Court. I sought help from colleagues at the Supreme Court of Appeal and at the Constitutional Court, and I received help. And the colleagues that I approached were very open with me and told me that, you know, what I'm doing now, helping you, I'm more than willing to do it because I also received help from other colleagues. And one colleague, you know, but maybe I shouldn't mention names, because once you mention somebody, it may offend the other to say, well, I also helped her, but she did not acknowledge me. Let me just leave it there to say, I have received help and I have reciprocated.
Just in following up, CJ. So I think the candidate that was here before you and even yourself, you are confirming that they definitely, in fact, that was the words of the former candidate to say that women generally need to get more attention in being developed within the judiciary. So I'm sure in terms of what you are saying, you agree that there is definitely that need. So you agree with me that you will have to sit down possibly and develop in a structured fashion an introduction or a program that will assist you to make sure that there is a development of particularly female and black female for that matter, in the general sense, to be mentored and to be guided and to be developed. I think we agree on that one.
Absolutely.
How would you want your colleagues to remember you, particularly in the light of your seniority, for your contribution to their own development? How would you want them to remember you?
As somebody who had empathy, who was always willing to assist despite the hectic schedule of our court, not only in relation to matters of work, in other words, our workload, but also in relation to personal matters as well. Just creating a platform where people feel being approachable, basically.
Thank you, CJ. Thank you, Justice.
Thank you, Honorable Lucas. Commissioner Sigogo.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
I had two questions for you, but you dealt with the first one in respect of your judgment, the Marudi judgment. I wanted to talk to you about that judgment, particularly as to the courage that we had to be alone when four other people were not seeing the same way you did, and you were then ultimately confirmed by the Constitutional Court, but you have dealt with that part. And when I read your judgments, I see consistency in terms of reasoning. Then I would like you to share with the Commission as well as the public at large your judicial philosophy. What is it?
You know, judicial philosophy has to do with how you interpret the law, your approach in how you interpret the law. And historically, people would say, I'm liberal, and then somebody would be described as conservative and so forth. But we are now in a constitutional democracy, and the Constitution is the supreme law of the country. And I don't think it's up to individual judges to decide, this is my philosophy. You just have to comply with the provisions of the Constitution, Section 39 in particular, in relation to the promotion of the values that underpin the values, the dignity, all the values, human dignity, freedom, and so forth, to respect all those values and to recognize that the Constitution is binding, it's imperative, and so there has to be, let me call it, for lack of a better word that I can think of now, predictability. We should know that when the circumstances are like this, the outcome will probably be like this. So we use the Constitution as our guiding principle. Judges and courts are the guardians of the Constitution. So I would not stand here and say I'm liberal. My philosophy is that I should be liberal or like this. What I must do is I must just go according to what the Constitution instructs me to do. And you will note that in the preamble, it sets it out very clearly what everybody wanted in the first place. And what everybody wanted was, to heal in the main, to heal the divisions of the past and to establish a society that respects fundamental rights, that is based on social justice and the values that are in the Constitution. And that's basically what I do. I think in most of the judgments, you will see that there's always a reference to the Constitution, simply because it permeates all areas of the law. It does not matter that it's a matter that relates to contract, that relates to personal injury or whatever. The Constitution is the overriding principle.
Thank you, Judge. Thank you, CJ.
Thank you, sir. Commissioner Madonsela.
Thank you, Chief Justice. Good afternoon, Justice Molemela.
Good afternoon, Commissioner.
When I survey the path that you have taken in your judicial career, seems to me, and please correct me if I'm wrong, seems to me that you have been a judge in the Free State Division. You headed that court, and that was not long period of time to head that court. You moved to the SCA, and you have been at the SCA now for 3 years. Now you want to move to, you're applying to go to the Constitutional Court. It worries me that as I look at the work of the Judicial Service Commission over the years, there's been a struggle to get women as strong as you to assist the JSC in its task to turn around the judiciary as a whole in the country, in various parts. And you took your part in Free State. And I would imagine that in the SCA president would have relied on people like you to make a change in the demographics and even the strength of that court. We're coming with people like you. Now we are 3 years there, now you want to move. And are you not going to move to The Hague when we take you to the Constitutional Court? Soon after we appoint you, I'm worried about your quick movements without allowing us to work around you and rely on you to shape up the judiciary the way that we want. We seem to be having you moving along too quickly. What do you say about that? What's the point of this?
Thank you, Commissioner. I think I can call it a perception. It's a perception that you and maybe a few people have, but I think what people do not realize when they read my CV and see the different positions that I have occupied and the courts I've worked at and so forth, people tend to think, oh, okay, she was appointed at the High Court in 2008. And then, it means that In 2012, she left the High Court and went to the Labour Appeal Court. And then she left the Labour Appeal Court and went to the Competition Appeal Court and left that court to become Judge President. What people do not realize is that actually I spent 10 years in one court, and that can hardly be called a quick movement. I was I was appointed permanently in that court in 2008 and moved to the SCA in 2018, 10 years. And most people don't realize that because they think that I've been moving from this court to the other. What happens is that you hold that position while you are still based in your division. So if there's a competition appeal court matter that I have to participate in, I would go to Cape Town to go and deal with that matter and come back and participate in the role. And you are not even given time off, while you are reading those voluminous records of the competition appeal court, you are not given time off at the High Court. You still
can I agree with you? 10 years at the Free State was good. Can we focus on the SCA?
All right.
3 years?
Yes. I would say 3 years is more than enough when you consider the following, that for me to be appointable to the Constitutional Court, I did not even have to go and serve at the SCA in the first place. Let me make this example, and I'm going to mention a name, and I'm doing this with all respect and humility to say we had and it's a lady that I'm very proud of, Justice Kate O'Regan, who from being an academic went directly to the Constitutional Court. She did not become a judge at the High Court. She did not become a judge at the Supreme Court of Appeal. And that was perfectly acceptable. And she made a huge contribution. And then there was another female judge, and I know she won't have any objection to me mentioning her name, a lady that I respect, Justice Besson Kabinde. Justice Besson Kabinde was a judge at the Northwest Division, and then went and acted at the Supreme Court of Appeal, but never accepted appointment at the Supreme Court of Appeal, and instead accepted appointment at the Constitutional Court. And of course, we have one of our luminaries, Justice Krichler, who was at the SCA for only 2 years before he was elevated to the Constitutional Court. So
I won't say about Justice Krichler, say more about Justice Krichler at the moment. Can I just, maybe I should give a chance to the others. I had a question, but I think because of time, I'd like to give others.
thank you, Commissioner.
Honorable Minister.
Yeah, thank you very much, CJ and Judge Molemela. My question is in relation to the background that I see that you're an attorney in practice, and you have stated here that you have run a very successful practice as a female practitioner with other female practitioners. We are confronted with the challenge that I suspect you also were confronted with when you started practice. Across the country, in particular, female attorneys are crying about access to work. As you are aware, the state attorney hardly briefs attorneys. I'm particular now about female practicing attorneys, where they go to Polokwane, Molemela, Umtata, KZN. It's a public outcry there. How did you succeed to be even in the panel of private firms, including that one of the state, and still run a successful practice under the circumstances that I am describing?
Yes, thank you, Minister. I was a member of the Black Lawyers Association, and just after 94, we formed a committee that was called the Empowerment Committee. And I was part of that committee. I served in the Empowerment Committee, and the role of that committee was to go to different government departments, to all the parastatals, to all the banks, to remind them that there are Black practitioners and they are also capable of doing the work, and to ask them to consider including us as Black practitioners in our panels. And I do recall that when we did that, the issue that was always being raised was, but we want a company that has a track record. For example, to us, they said, we can't give you any conveyancing work because you don't have a track record. And that was around 94, 95. And I remember the answer that we gave them was, but there's just no way we could have a track record in conveyancing matters when we were not even allowed to own land. So whose property, whose land would we be transferring? That's why there's a paucity of members in as far as conveyancing is concerned. And so I think that helped a great deal. And there are a few practices, attorneys practices that were put on panels, but sometimes, of course, you would be put on a panel but not be given work. I can mention that there were 2 banks. We were on the panels of 2 banks, and we didn't get any work from them. And eventually we went to them and demanded that they should remove us from their panels because they were just window dressing, because they were able to say on our panels, we also have this particular firm. It's a Black firm. It's a firm where the directors are females and so forth. But then we were not getting any work. So my answer to you, Minister, would be that, there has to be a conscious effort to try and get work for Black practitioners. Not only the attorneys, the advocates are also struggling. I know this for a fact, because I know that at the Supreme Court of Appeal, at the Constitutional Court, we hardly saw any ladies over there. Not to say that there are no women that are like me that are sufficiently qualified to do those cases. There are, and they have received training and they have the necessary qualification. But I think what is lacking is the will, to consciously empower these people. Briefing patterns and the skewed briefing patterns has been a topic. It has been something that has been lamented upon ever since I started being a judge. I think in my very first interview, there was a lamentation about that, but we don't see any serious improvement about that. I know that there was a stage when we saw practitioners in the streets, Mr. Sigogo, and protesting basically. And we know that it is an issue. Am I wrong?
No, you're not wrong.
You're correct.
Yeah, I'm correct. Yes, I know.
Yeah, no, you're not wrong, Judge. I'm being deliberately specific with the female practicing attorneys and not going to the advocates, because I think that one of advocates, it has been thoroughly exhausted, particularly in this platform, on the issues of skewed briefing patterns and the difficulties that the advocates at the bar have, including the female practicing advocates. But the issue of attorneys, females in particular, has not been as exhausted as I have heard in terms of the discussion. Hence, I'm asking you particularly about the female practicing attorneys, because as you are aware, across the country, as you engage with them, it's an issue that they always raise. And I think it's also exacerbated by the fact that the state attorney does not really brief attorneys, whether a female or Black. It's only on correspondence work. So I'm asking you on the basis that you have ran a firm of attorneys, females, and that seems like there was some kind of measure of success. So what will be your advice to us as the state, but also to the private sector out there with regards to this issue of the briefing pattern? I know that the Legal Practice Council is currently developing a legal sector code that will put some kind of a monitoring mechanism that will check in that regard, particularly issues addressed to female practicing attorneys. What should we really do? I know that it has been engaged over years and years, and I also had the same problems, you had the same problems. But do you think that the legal sector code could be the best suitable mechanisms in that it will have a mechanism of monitoring and reporting that this is how the female attorneys are being briefed across the country?
Yes, it will definitely have a positive spin-off. I have no doubt about that. The question is whether it will be implemented, because in most instances, we have beautiful things on paper that are not implemented. I mean, the whole issue of briefing patterns, undertakings have been made many times that support is going to be given to the Black practitioners, both advocates and females, and attorneys, Black females included. But as to whether that is actually implemented, I don't know. I doubt it very much because I don't see it happening. So all I will suggest is that there has to be an interaction, serious interaction, maybe form a committee or something where there's interaction between government and the office of the state attorney, to monitor them, to actually see that whether they are implementing this and by empowering women, and contacting different state law advisors, because state law advisors are there, they give advice, and then eventually when the brief is issued, it goes to a white firm, and talk strongly to them to say, this is what we want and this is what we need to see happening. Because I think
maybe on that point, Judge, what then do we do with regards to the private sector? I get that the state attorney, which we have done, the Solicitor General is already having engagement with the Legal Practice Council. What then do we do with regards to the private sector? Because the private sector, as you are aware, operate in the many parts of the country, in some of the remote rural areas where government has no real control as to who ABSA, Standard Bank, SAPI, or any private sector company. What then do we do with that aspect? At least you succeeded, but in this instance, what then do we do so that they do the same thing that ourselves as the state attorney are required to do? And we commit that we will follow up on that and report again in this platform. But with the private sector, what then do we do? That legal sector code is aimed to do that, but how do we ensure that they also implement?
The private sector, there's something that is called BEE rating, and for them to get government work and so on. For example, we made an example with a bank. For a particular bank to hold the government account, for example, you could say to them, this is what we require, 1, 2, 3, 4, 5, and then thoroughly check whether there is indeed compliance. An issue that has worried me in as far as that is concerned is that you'll find that a company has a good empowerment rating in the sense that they tick all the boxes relating the presence of females and Black people, but what is not assessed is the duration of employment of those people. So you'll find that a company appoints somebody for a year, but this person is not treated well and soon leaves the firm, and this person is replaced by another Black person. After 6 months, this person leaves immediately thereafter somebody. So I think that when it comes to the scoring, the duration should also be taken into account. and the conditions, the employment conditions of those particular employees should also be taken into account. So it's all about seriously monitoring.
Thank you, CJ, and thank you, Judge.
Yeah, thank you, Minister. Professor Schlemmer?
Thank you, Chief Justice. Good afternoon, ma'am.
Good afternoon,
I am very impressed to see that you say that you read a lot and that you study a lot and that you have qualified yourself so far. How important do you think is it that a judge writes scholarly judgments, especially in the face of the fact that our legal system is not codified?
It's very important. It's actually it's part of accountability, but maybe I will qualify and say not necessarily scholarly, but a well-reasoned judgment. A judgment must have all the reasons for the decisions that are made. That is part of accountability. Let me make this example that if you were to give the correct order, but it is not accompanied by the reasoning, and the reasoning is completely wrong, then even an appellate court is not in a position to correct that reasoning because that particular reasoning is missing from the judgment. So where I'm not sure of your definition of scholarly, but my definition of an adequate judgment is a judgment that gives cogent reasons for the decision that has been arrived at. And that is what is required not only, but that is what is required by our code of conduct as well, that we must give reasons for our judgments. As to whether you in particular will consider them scholarly or not, I don't know. But it suffices if the judgment gives reasons for the finding or for the decision.
Well, I suppose when you give cogent reasons, that is based on authority.
Of course.
And that is what is a scholarly judgment.
Thank you.
Thank you.
Then all of them are scholarly.
Commissioner Mukesi?
Thank you. Thank you, CJ. Firstly, Judge Molemela, let me appreciate the fact that you have availed yourself for the Concord. And as I understand, in all the instances, even when you became the judge president at Free State, it was not your first choice. You were called upon because of other issues that have arisen there. So I appreciate the fact that you have availed yourself. Yeah. On the top 6, there is something that is related to it. The language that is used in the judgment of the appeal court when you address the judge in the court of call. I mean, you disagree with the findings. Things like she did not feel lack appreciation of facts, strong language such as had a total misunderstanding and misdirections on the facts of the case. I mean, the language, that's very important. But I don't want us to limit only when you direct to the judgment of the court. But in instances where there is a discretionary exercise which you disagree with, like, for instance, the public protector, the strong language used by the Concord itself, resulting in some cases where there were those personal cost orders which were set aside because they could not be. How do we address the issue in the judgment of the language by the judges of appeal in relation to the judgment that they disagree with, or an exercise of discretion by other organ, by other arm of government?
Thank you, Commissioner. If you have a look at Article 11 of our Judicial Code of Conduct, it talks about restraint, judicial restraint. And amongst other things, it states that there should be restrained in how we deal with not only the judges or the public protector, but with the litigants. You know, how we express ourselves about parties and issues. We must be very, very careful. So I think we must use temperate language, and we must ensure that we comply with that. I know that I think in 2012 we had a judges conference. It might have been earlier. And no, not in 2012. I think
it was 2009.
2009. Thank you, Chief Justice. Yes, we had a conference, and that's one of the aspects that came out that was discussed, and we all agreed that we must treat one another with respect, even though we disagree. It's okay to disagree. However, we must always show respect to other people. We must always be mindful of, if I think one of the provisions in the Constitution actually states that everyone has inherent dignity. So you have to treat everybody with dignity.
The other question that I would like to debate, I mean, particularly the black people, you refer to some cases. The black people have been oppressed for so many years, more than 365 ever since. Now, if, for instance, out of the judges, at one day an occasion can arise where all the judges in the CC, for instance, are all black judges, is there anything wrong? Would that be contrary to the provisions of Section 174 in the Constitution?
Well, thanks, Commissioner.
If yes, how? I mean, if you can school me there.
I think earlier on, in one of my responses, I emphasized that we have to comply with the Constitution because we are in a constitutional democracy. So if you consider the provisions of Section 174(2), it says when appointing judges, you must make sure that...
So you consider. Yeah. It doesn't say you must. You are not obliged. Take into account. It means you must take into account.
That's right.
Yes.
You must take that into account. And so as long as that has been taken into account, that will suffice.
Lastly, Chief Justice, I'm sorry. The last point I would like to check on is we have traveled a long way since 94. If one interprets the provisions under Section 174, particular subsection 2 that you referred to, or that we refer to, is it not safe to interpret that as to say that was in response to the status quo in 1994, where blacks completely were not either judges, were not even qualified, were not even entitled to? That was in response to say, let us address this aspect. Is it not time has come that the Constitution itself in this regards have to be amended to reflect current realities in terms of the tenure of judges, in terms of composition and also further?
Yes, thank you, Commissioner. In my answer, I will refer you to the separation of powers to say it is the legislature that enacts laws. And my duty as a judge is only to interpret the laws and to apply them. So I have no comment as to whether the Constitution should be amended or not.
No. Thank you, Chief Justice. Otherwise, wish you all the best in these interviews.
Thank you, Commissioner Nogesi. Commissioner Tsepe.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Very happy to see you. Judge, I just wanted to talk to you briefly. You spoke about the obligations in Section 39(2), and you spoke about your appointment, particularly in the Labour Appeal Court and the Competition Appeal Court. I wanted to ask you, what has been your experience in those specialist courts when dealing with the subject matters in those courts, but also in commercial matters on the observance by judges to the obligations in Section 39(2) when interpreting legislation or developing the common law or the customary law, to take into account the object and spirit and purport of the Constitution? What has been your experience in those courts?
I think by and large, as I mentioned earlier on, the constitutional values have been embraced. We know as judges that they are binding on us, and by and large there has been compliance. There have been a few judgments of the Constitutional Court where other courts, including our court, was criticized for not properly interpreting a particular constitutional provision. However, what must be borne in mind here is that, there is scope for error. There is no judge that is infallible. We are all fallible, but we try our best under the circumstances. And sometimes we do get the law wrong, or rarely the facts wrong, but that has, no bearing on the probity of a judge.
Thank you, Chief Justice.
Thank you very much, Commissioner Tsepen. Honorable Singh.
Thank you very much, Chief Justice, and it's good to see you again, Justice Molemela, even if it's on this virtual platform. I remember very fondly our interview in April of 2018, where I think Commissioner Molemela expressed some dissatisfaction with the CJ when the CJ said you were making a sacrifice when you applied for the position to the SCA from being the judge president. And I think we dealt with that matter at that time. But what I'd like to ask you, Justice Molemela, is in hindsight, do you think that not being the JP at that time and moving to the SCA, where you've done excellent work, has been what you have always wanted? And do you think that your contribution as a Constitutional Court judge, if appointed, will be one that should be worthy of our consideration? Given that you've only acted for 5 months in the Constitutional Court, but one would think, and I would like you to say whether or not the experience you've had in the SCA will hold you in good stead if you are appointed as a Constitutional Court judge. Thank you.
Thank you. Maybe I should start right where you left off, right at the end, to say, yes, definitely my experience at the SCA will stand me in good stead. But not only the experience at the SCA, the experience acquired also from the Labour Appeal Court, the Competition Appeal Court. And yes, and I mentioned earlier, maybe I'll just mention it again, that I think I am ready. I have broad experience. I'm an all-rounder. And I think I will be equal to the task of being a justice of the Constitutional Court. In relation to your concern about having been at the SCA for only 3 years, let me just allay your fears or your concerns by reiterating what I mentioned earlier on, to say that I did not even have to go and accept appointment at the SCA first. I could have made myself available as a judge president, for example. I could have made myself available at the Constitutional Court, and there would have been nothing wrong with it. And maybe I'll just add that I was, just reading to see what's happening in other jurisdictions. And I noted that in the United Kingdom, for a judge to go and serve in the apex court in that country, you only need to have done 2 years at the former court, meaning that my move from the SCA to the Constitutional Court, I would have had to be at the Supreme Court of Appeal for only 2 years. So by all accounts, it seems that I can be considered to be ready to take that appointment.
No, thank you, Judge. No, certainly, it's not a concern of mine that you hadn't served long enough in the Constitutional Court. In fact, I think you've had excellent grounding at the Supreme Court of Appeal, because the principles of law would somewhat apply similarly at both levels of the court. I'd just like to ask you a question. I don't know if it was humility or omission in your questionnaire where you did not put in the fact that you were Judge President in the Free State. I would take it as an omission, because when I looked at that and I said, but I remember Justice Molemela, and certainly she was JP. It's on page, one of the pages. I'm looking at the page now of the questionnaire that you filled in. But let's take it as an omission. You spoke earlier about dissenting judgments, and you have written dissenting judgments. What I'd like to know is, at the level of the Constitutional Court, what is your view on writing dissenting judgments or minority judgments? And how would you apply yourself if you do not agree with the majority on a principle or a matter of law? Thank you.
Thank you. You know, before a judgment goes out, it's preceded by very robust discussions and debates amongst the panel members, both at the Supreme Court of Appeal and at the Constitutional Court. And so when a judge eventually writes a dissenting judgment, it's after careful consideration and, you know, being of the view that there is this particular view which needs to be aired, in the sense that be put out there in public. Dissenting judgments in most instances do not talk to the present, they talk to the future. Because if the legislature decides that there's a particular statute that needs to be amended, a statute that needs to be amended, it will take the judgments into consideration, both the majority judgment and the minority judgment. So there is a place, definitely, for a minority judgment, even at the level of the apex court. So, and, you know, I considered a number of judgments of the Supreme Court of Appeal, because I believe that, you know, you must always benchmark and consider what happens in other jurisdictions. And I've seen a number of their judgments where there are dissenting judgments, many of them. And so there's absolutely nothing wrong with that. It's just a view that is held by a particular judge, that the judge feels strongly about, that the judge feels that it should be aired. And as you could see, sometimes the minority view ends up carrying the day, as it has happened in the case of Murudi, although that had to happen after the intervention of the Constitutional Court. So there is definitely a place for dissension, and it is in fact encouraged, not only a dissension, but the writing of separate concurring judgments as well, because the next court, it is to the advantage of the next court to have as many views on the aspect as possible.
Thank you. I know you don't have the Constitution in front of you there, but 174.1 was referred to 174.2, Chief Justice, and it says this: the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are appointed. I just wanted to read that section of the Constitution to you and for Commissioner Nochesi. Thank you, Chief Justice.
Yes.
Thank you, Honorable King.
May I respond to that,
Deputy
please?
President Petzel. Oh, you need to respond? Okay.
Yes, I wanted to respond.
If you want to, Justice, please go ahead.
Yes, I want to respond by saying that unfortunately at the moment, that constitutional imperative of Section 174 has not yet been achieved. Even in my first interview, there was a lamentation about the fact that the judiciary, there's no gender parity on the judiciary. And that was in 2008. It is now 2021, and that is still the case. There is not enough representation of females in the judiciary, meaning that that section that you have just alluded to, Commissioner, has not been complied with. It's a serious concern because we know the reason why things are as they are. Speaker after speaker after speaker on the lack of representativity will tell you that at the bottom of that is patriarchal practices. I mean, there was a stage when in 1912, a female judge, a female attorney, aspirant attorney by the name of Wookie was not allowed to practice as an attorney because apparently she did not fall within the definition of person as defined in the statute that regulated the admission of attorneys. So the reason is not hard to find why there are few women in the legal profession. And if we accept that patriarchy is at the bottom of that, then we need to deal with it. Patriarchy has been dealt with in a number of stages. For example, there was a stage when a woman had to get consent from her husband for everything that she needed to do because of marital power. It was abolished in 1984. In the case of Bay, the former DCJ, Moseneke DCJ, lamented patriarchy and its effects and mentioned that it is what lies at the bottom of the perception that women are subservient to men. And in that case, that custom was done away with of primogeniture. Now, my question really, and this is something that is troubling me, is why do we address it when it comes to certain things, but when it comes to others, we don't? Why don't we see an equal representation of women and men on the bench? For a number of years, it was stated that women were not sufficiently qualified. Women have been trained. There are now many women that are sufficiently qualified. And then it was stated that women are not making themselves available. But we have seen that even when competent women have made themselves available, sometimes they do not get the nod. So what are we doing? When we abolished marital power and when we criticized primogeniture, we inter alia stated that it creates a bad impression about women, that they are not equal to men, trampling on Section 9 of the Constitution, which deals with equality. Now, how can we allow it to be the order of the day when it comes to our courts, the very guardians of the Constitution? I looked at the statistics and I've seen that in the continent, not too far away from here, in Zambia, the representation of female judges there is 52%, which is in line with our demographics. And I've asked myself, why have we not achieved that? And I read a statement that was made by the Chief Justice in that country, who said they did this because, amongst other things, they were complying with the protocol on, I think it's called the Protocol on Gender and Development. And South Africa is a signatory to that protocol. It was signed in 2008, and it was amended in 2016 to bring it in line with the Sustainable Development Goal 5. So that's how they achieved that. Now, the same protocol is binding on us, on South Africa. How come we are not complying with that as well? Should we keep comparing ourselves to the countries that are performing badly? And yes, I know that there are some first world countries where the representation is not what it should be. In fact, when I looked at the statistics of Canada, I saw that female representation on the bench is about 35% thereabout. And when I had a look at their family courts, the representation of women is about 65%. So in my view, that is just, perpetuating the stereotypes that we have about women. And it pains me to be part of an institution where you are sitting there and the court is not representative. We are in a country where several households are led by women and they are doing a wonderful job. What goes wrong now when it comes to putting those women in positions of authority like being a judge? Especially when actually there's an obligation to comply. And in 1994, the former president of this country, our beloved Madiba, made a speech. And the speech that he made was at the opening of Parliament. And amongst the things that he mentioned there, 1994, 27 years ago, was that women must be empowered and they must be represented in all positions. I'm just paraphrasing what he said. So actually what we are now finding in the protocol is something that was articulated very well by Nelson Mandela in 1994. We are still not there yet. It's painful to sit there and envy other countries. I attended the International Association of Women Judges Conference in Argentina 2 years ago. And there were women from many countries all over the world. And we could just, envy a lot of them who were saying that we have achieved representation. I think France was one of those that said their representation is already at 70%. And perhaps one can say, no, but those countries are first world countries and so forth and so forth. But I want to go back to Zambia and say, here is Zambia, they have done it. Why can't we do it? Thank you, Chief Justice.
Thank you.
Chief Justice.
Thank you.
Chief Justice.
Deputy President Benson.
Chief Justice. Julius.
Yes, sir. Yes, sir, Honorable Malema, is that follow-up?
No, I was just saying it's 2:10.
Yeah, no, I didn't know what to do, quite frankly. For the first time, I didn't know what to do. Can we just deal with the remaining ones, or are you proposing that we take a break and bring her back? I thought maybe we must dispose of Justice Molemela. We have 3 people, including me, put questions, and then I will implore her to be brief where she can, and then we go for lunch.
No, I agree with you, CJ. I was just saying if you can plead with her, just to take into consideration that it's 2:10.
Yes, Justice Molemela, in your responses, please just be as brief as possible.
Chief Justice, Schlemmer here, if I might may have a follow-up after everyone is finished, please. Or just before you
do it now.
Thank you.
Do a follow-up now, bro.
Thank you very much. I think I should just give a little bit more clarity. I was a little bit taken aback by the reaction of the commissioners when I said the scholarliness of a judgment include references to authority. When you say you do research and you write judgments with reference to authority, my question also pertained to the issue that the South African legal system is uncodified. Do you ever refer to discussions of case law? Do you ever refer to any other academic materials that were written on a particular subject matter? Because that adds to the authority and the well-reasonedness of a judgment. And we have seen over the years, I don't know how many years, we can see that there has been less depth in judgments and in the reasoning of judgments.
Well, there are many judgments that refer to published articles, and I too have referred to a number of articles in my judgments.
Thank
Thanks,
you.
ma'am.
Thank you, Deputy President Benson.
Thank you, Chief Justice. Good afternoon, Judge Molemela.
Good afternoon, Deputy President.
By way of observation, I must place it on record that I am grateful to you for putting things in proper perspective in relation to the current working environment at the SCA, especially with reference to the remarks, if you will still recall them, that you made after the hearing I had together with you and other colleagues on the 11th of March 2020. I just thought that I should place that on record. Then my first question to you, and I would like you to comment on this. You know, when we speak of the independence of the judiciary, the focus is on institutional independence and not individual independence. And I must say that I admire your fearlessness to dissent when you're convinced that the majority is wrong and you are right. And would you care to comment, if you may, on the importance of individual independence?
Thank you, Deputy President. There are a number of elements to individual independence, and one of them is security of tenure. You know that as a judge, you should be able to be fearless in your judgments without worrying about the repercussions thereof, that you might lose your job and so forth. And there is security of tenure in as far as South Africa is concerned. So that is not my worry. And the second element of individual independence is that you must be free to make a decision without being influenced or attempts of being influenced by other people. It doesn't matter who it is, in relation to how you should find or what outcome you must give in a particular matter.
Thank you. Incidentally, I read a judgment of the AD, as it was then called, when 5 judges of that court said that their colleagues who had 10 years ago found that a judge in the KZN High Court was wrong, were in fact wrong, and the High Court judge was right.
It happens.
Then the second one, given that Commissioner Molemela has impressed upon us that it is now 2:10, is more a lamentation than a question. I take it you will agree with me that the president of the SCA is doing her utmost best to reinforce the SCA. And no sooner has she done that than our colleagues are snatched by the Constitutional Court. Why do you want to leave us only after 2.5 years with the SCA?
I will skip the part where I have to repeat that I did not even have to go to the SCA in the first place, because I've mentioned that before. I I'm of the view that I've really done my part, contributed significantly, and I think it's time to move on. And in line with what I've always stated in all the interviews, you know, when a position opens up, if I am appointed to the Constitutional Court, a position is going to open up, and I can assure you that there are many, many women who will be able to fill those shoes.
So you reckon that you do well to enrich the jurisprudence of the Constitutional Court?
By enriching the jurisprudence of the Constitutional Court, I'll be enriching the jurisprudence of the whole country because of the doctrine of precedence, meaning that the judgments that I will be writing there will be binding on all the other courts. So that will still be a benefit for the other courts, including the Supreme Court of Appeal.
If you are recommended and ultimately appointed, would you be charitable to us and not come hard on us when you upset us on appeal? Thank you. Thank you, Chief Justice.
Thank you, Deputy President. Judge President Mlambo.
Thank you very much, Chief Justice. Justice Molemela, good afternoon.
Good afternoon, Judge President.
You dealt partly with the issue I want to raise is when you sit on appeal, you sit in a panel. And I would imagine you've been involved in more male-dominated panels than where females are in the majority. Am I correct?
Yes, because of the demographics, yes.
Yes, I think I'm coming to that point. But have you been able to sway the thinking of the panel in terms of the direction of the judgment in when you deliberate after hearing matters? What has been your experience? I mean, has there been condescending to you? Have you been treated equally? Have you been able to sway the thinking of the panels?
I have been treated with respect. My views have been entertained. I did mention that we have very, very robust discussions. I've never felt that I'm being undermined. Even when other people had a different view, I respected the fact that we are not a homogeneous group and we will not always agree on everything. And there's space for dissension. But yes, I have been able to sway. And I think I did that in a matter where you were the presider while I was at the Labour Appeal Court. Yes, Judge President Mlambo. You might not remember this, but that was a matter where we had a discussion and I swayed the court and we came to the outcome that I had suggested and given reasons for, and eventually it carried the day. And the panel was of the view that it was so good that it could actually be handed down. And I handed the judgment the very next day.
Thank you very much for that assurance, because I was just responding to what you were saying about the demographics and not being given opportunities and not being recognized as equal partners in this trade.
Yes.
Incidentally, that's a panel that involved 2 judge presidents and you were able to sway them.
Correct.
Well done. Thank you very much, Chief Justice.
Thank you, JP. Just 2 quick ones, Justice Molemela. The question that Commissioner Madonsela put to you and Commissioner Singh and Commissioner Betze, I think you need to confront it so that it doesn't unduly prejudice you during the deliberations. 1, you were a judge president for 3 years, from 2015 to 2018.
Correct, CJ.
You get appointed, people get excited. There's been a paucity of women at the leadership level, and the expectation is to build around this woman leader. 3 years down the line, you leave for the Supreme Court of Appeal. Well, there's a celebration. At least the Supreme Court of Appeal is transforming. Number of women is increasing. 2 years, 11 months, and 13 days down the line, you are quitting. So confront it. We all know that you are not bound to first become judge president or to first become an SCA judge before you can go to the Constitutional Court. Why does it look like you can't stay in one place, influence that place significantly before you can move on? As Commissioner Madonsela said, why shouldn't we suspect that you'll soon be going to the Hague or whatever, either to the ICC or the ICJ? Why do you appear to be moving so soon after elevation to a particular position? Just explain it.
Well, CJ, if you recall, in relation to my appointment as the judge president, I mentioned not only me, all the candidates mentioned the problems that we were encountering in our court. And you'll remember that there was just one problem and it related to the role. So it was not a big challenge that could not be attended to. And that's the first thing that I did when I was appointed in that court. And the division was running like a well-oiled machine. The reviews that we were getting, many times it was voted as either the top or maybe the second best performing division in terms of the statistics that were issued by the NPA. It was a well-run division. And I held the view that I had achieved my task. But consider what I did while I was there. I empowered other women. 3 women acted in the position of judge president. I gave them an opportunity to act in the position of judge president and deputy judge president. So my leaving that court did not leave a void, because immediately after my departure, 2 ladies continued acting as the deputy judge president in that division.
Yes.
And so,
if I may interrupt you, I'm sorry, if I may interrupt you.
Yes.
Now, here is the problem. You've been lamenting the underrepresentation of women at the leadership level. You left and you strongly recommended a man to replace you.
Yes.
Undoing the progress that was done there.
Yes.
That is the point.
Yes, there were many considerations, Chief Justice. There are a lot of considerations. You consider experience as well. And as I mentioned, there were 3 ladies that had acted as the deputy judge president, and 2 of those ladies have now made themselves available for appointment in the vacant post. And hence I say there was no void. But let's look at the bigger picture as well. I left and I went to the Supreme Court of Appeal, where at the Supreme Court of Appeal, there was also a problem regarding representation. Many positions have now been advertised and they will be filled next week, or in the course of this week, sorry. And I'm quite sure that the provisions of Section 174 will be taken into account in filling those positions. And now look where I'm going, and let's look at the representation in that court. So in the same way that you mentioned that there was an applause when I joined the Supreme Court of Appeal, I'm quite sure that there will be an applause if I join the Constitutional Court, because it will be a woman adding to the existing complement in that court. Yes. And as I stated, Chief Justice, this whole thing is like a chain with many links. If you pull just one link of the whole chain moves. So my leaving the High Court created a vacancy in that vacancy of a judge, a female judge was appointed. That in itself has improved the statistics. I went to this Supreme Court of Appeal. It improved the statistics in that court. I leave that court. Women are going to be appointed to that position. In the end, when we sit down and look at all the statistics, we might find that actually the gender representation has improved a great deal. If we are going to move along those lines, replace the ones that are leaving with female candidates, because there are many female candidates out there.
Yes. All right. One last question. There is what I think is a malicious attempt to soil your name and the name of other judges. And it moves in circles. You know, it's been recycled. That's what I wanted to say.
Yeah.
After a few months, the thing is on social media, and people, the person, the people, or the thing, because we don't know whether it's a juristic person or what, running by the name of something where after a few months, the thing is cycled again, and everybody now is shouting, oh, there is corruption in the judiciary, and nothing has been done about it. What have you uncovered about the so-called Mape who keeps on making these malicious allegations of involvement in corruption against you and other judges, or bribery against you and other judges? I think it's important that you confront it on this platform.
Yes. GCJ, you know, there's a book on this. I think the title is The Smear. And
yes.
Yes. And we must accept. It's a reality of life that from time to time attempts will be there to have a smear campaign and to try and soil your brand. It has happened in this country. I'm not the first judge. I read the former DCJ's book, and he mentions in that book, and in actual fact, he even he has incorporated a letter that he received from the president. Let me step back a little bit to say, he states in the book that he and another judge, Judge Froneman, were accused of having been spies. And there was
yes, and Westhuizen as well.
Yes, and there were and Van Westhuizen, yes, and there was an investigation, and they were cleared. So quite clearly, those allegations were baseless. And then there were allegations about myself and other judges on the Free State bench. And I remember I had a discussion with Justice Musi, and Justice Musi said, you know what? Let me tell you, you'll see that if nothing is done about this, next week other names will be mentioned, and the week thereafter other names will be mentioned, and so it will go. And that's exactly what happened. If it's not a week later, 2 weeks later, there was another list that went out, included a number of colleagues, including some who have made themselves for appointment to positions at the Supreme Court of Appeal. And recently there was another list that was circulating, and it mentions more names. So what happens? If I have to give you an explanation, I don't know why people do such malicious things. In as far as this tweet is concerned, I and the other judges laid charge, and we discovered that this person is using a fake name. So the account is a fake account. And the case was reported to the Hawks. It was being investigated by the Hawks, and they were part of their mandate was to get in touch with Twitter to try and identify this person. So more than what we have done, CJ, we cannot do. There are allegations from time to time about many judges, and I hope, I mean no disrespect, to mention that you too, and you have been upfront about it, to say that you too, false allegations were made against you too. And as a matter of fact, In that very tweet that you are referring to, a false allegation is made about you too, because it is
Yes.
it is stated there that you were told about that and you did nothing. And
And it's a lie.
it's a lie. It's a lie.
Thank you, Justice. Sorry we kept you very long. You are excused.
Thank you, Chief Justice and Commissioner.